Mr. Jordan, let's try again.
Yes.
Please don't apologise. We've encountered all manner of technical problems. So
Thank you very much, my lord. So the question that arises first is as to the interpretation of the contrary to public interest ground in section 84 1AB, and what are capable of being material circumstances which are to be taken into account. In its written case, the appellant submitted that the question of what factors were to be taken into account was entirely a matter for the upper tribunal, who was intended by Parliament to not only weigh the right material circumstances, but decide what they are. That appears to have been abandoned in my learned friend's oral submissions, and it certainly should be abandoned. The question of what are and what are not material circumstances is a question of law to be decided as a matter of statutory interpretation. It's not something that the upper tribunal has power to conclusively determine. And I would draw attention to a decision of this court in relation to another statutory discretionary power vested in an expert tribunal, Devine Investments and Benson, which we referred to in our written case, and which concerned the power of the Leasehold Valuation Tribunal to direct that certain consultation requirements, which should be gone through by a landlord before spending money on major works, can be dispensed with. And in the majority judgment given by Lord Newberger, emphasis was placed on the importance of consistency and predictability in the exercise of a statutory discretion by an expert tribunal. The minority approach by Lord Pope was to say these are all matters that Parliament has left to an expert tribunal, but that was not the approach of the majority, and it is not the right approach. The right approach is the appellate courts to scrutinise the approach taken by the upper tribunal to the exercise of the Section 84 jurisdiction to ensure it's being implemented and acted upon by reference to the correct material consideration, and that is what the Court of Appeal did here. One other point by way of introduction.
Sorry, Mr. Jordan, could you please give us a reference to that authority?
My lord, yes, it's in the supplemental bundle, tab 4, page 84.
Thank you.
The other thing I wanted to say by way of introduction is that the appellant has relied on various passages in Hansard, which were also cited by Lord Justice Carnworth in Shepherd and Turner, but the House of Lords held that references to Hansard are inadmissible where they are sought to be relied on as illustrations of how a statutory power might or might not be put into effect. And the authority that I refer to is the Spath Home case, which is in the main bundle, tab 25, page 1331, and the relevant parts of the speeches are page 1374, Lord Bingham, page 1390, Lord Hope, and page 1395, Lord Hutton. In that case, the question was whether a power to restrict rises in rents was one intended to be exercised only to limit general inflation, or whether it could also be exercised to protect tenants. And the majority in the House of Lords said it was illegitimate to look at Hansard in order to decide that question. So, turning to the substantive issue, my first position is that there is a public interest, and a strong public interest, in deterring developers from acting in a high-handed and unreasonable way, and in encouraging them to act in a reasonable way, and in particular to ensuring that developers do not benefit, are not rewarded for deliberate breaches of covenant. The appellant says that matters of that kind have no part to play in assessing whether the effect of a covenant in impeding a use of land is contrary to the public interest. That is to give the phrase contrary to the public interest an extremely narrow reading, to confine it to one sort of public interest only. And there is no justification in either the language or the policy of Section 84 for such a narrow reading. My learned friend is quite right to say that it is implicit in the upper tribunal's decision, in particular paragraph 106, that the upper tribunal did take that narrow approach, but they were wrong to do so. It is in the public interest to encourage developers who wish to build in breach of a restriction to identify, if they can, the persons who have the benefit of the covenant, to speak to them about what is proposed, to see if there are any objections, and if so, whether they are reasonable objections, to see if it is possible to redesign or design the development in a way which takes account of those objections, and if there is to be some prejudice to the neighbours, to see if they will accept a reasonable sum of money in satisfaction of their legitimate complaints. The advantages of encouraging this sort of behaviour are, we submit, obvious. It gives proper respect to the property rights of the neighbours, it respects their feelings, and in this area of law we are concerned as much with people's feelings as we are with questions of money, and it makes disputes much less likely. On the other hand, it is very much not in the public interest to reward a developer who does none of those things, starts building knowing that they are building in breach of covenant, and when someone with the benefit of the covenant comes along and says, you're acting in breach of covenant and what you are going to do is going to interfere seriously with the amenities of your neighbour, ignores them and ploughs on regardless, and then only applies to the tribunal once the development is completed. The statute focuses attention on the effect that a restriction has in impeding a reasonable use of land. And the question is whether in impeding that use, the covenant is operating contrary to the public interest. In circumstances such as the present, if the covenant is not modified so as to permit the development, the impeding effect means that the issue will be decided by the court rather than by the tribunal. And in the case of a developer who acts in the way that Millgate acted in the present case, it is very much in the public interest that the court should decide the appropriate outcome, whether that be an injunction, negotiating damages, or even an account of profits. This is a case, as the court has seen, about an application which would not have succeeded if it had been made prospectively. It only succeeded because it was made retrospectively. As the tribunal held, Millgate could have carried out its development and provided 23 units on the non-burdened land, the unburdened land. Or it could have negotiated a payment with the local authority, as it did in February 2016, when the local authority said it was happy to take £1.64 million in lieu of the provision of the 13 units constructed on the application land. Therefore, the Court of Appeal was, we submit, quite correct to hold that in deciding whether the restriction in impeding a reasonable user of land is contrary to the public interest, to have regard, and to say that the upper tribunal should have had regard to the conduct of the developer. But there is, and I think my learned friend accepted this in his opening submission, there is a well-recognised public interest in ensuring that people do not get rewarded for deliberate wrongdoing. This principle, this public interest, applies as a matter of statutory interpretation, even where the statute itself makes no mention of the public interest. In an appropriate case, the court will imply into a statute a proviso that even though the conditions for obtaining some benefit are made out, if they only exist because of a piece of wrongdoing by the person claiming the benefit, then the benefit will be denied them. My learned friend referred to the Welling-Hatfield Council and Secretary of State case, a decision of this court, which is in the supplemental bundle at page 327. I won't go to that as the facts were really very different. It was about a developer who applied for planning permission to put up a barn, got planning permission to put up a barn, put up something that looked from the outside like a barn, but inside was in fact a house. And then after 4 years says, well, there was a change of use to use as a single dwelling house. There's a 4-year time limit for enforcing against the change of use to use as a single dwelling house. The 4 years have passed, therefore my use is lawful. And he lost in the Supreme Court for 2 reasons. First, there had never been a change in use. But secondly, even if there had, because of his conduct in deceiving the planning authority, and that conduct having prevented them from taking enforcement action, which otherwise they would have been able to do so, there was a sufficient nexus between his wrongdoing and the benefit he sought to obtain to deprive him of it. But closer to the position here, I submit, is the case of Henley and Cohen. I would like to take the court to that. That is in the supplemental bundle starting at page 201. And this was a case under the Leasehold Reform Act 1967. The 1967 Act says that a tenant of a house who has been the tenant for 2 years may claim the freehold from the landlord. And the question of what is and what is not a house has given rise to some difficulty, including decisions of the House of Lords and the Supreme Court. In this case, the property was a shop with a storeroom at first floor level. The tenant, in breach of covenant, converted the storeroom into a flat and then said, now the building is a house and I can claim the freehold. And if the court could please look at page 203.
Yes.
And paragraph 5 in the judgment of Lord Justice Mummery, he explained that the case fell into 2 parts. The first was whether the building was a house reasonably so called. And the second part of the case is whether the unlawful conduct of the present lessee in the building, the claimant's appellants, who with a view to enfranchisement deliberately acted in breach of covenant by carrying out works to adapt the upper floor for living in, disqualifies them from acquiring the freehold that belongs to the present lessor freeholder. And that was the part of the case which is relevant here. Now, there was a covenant against altering the plan of the property. The tenants asked for the landlord's consent. The landlord refused consent, but the tenants went ahead nonetheless. So close similarities to the position here, except in our case, the developer didn't even ask. And then if I can ask the court to look at page 323 next. Page, it's not right. It's paragraphs 59 to 60 of the judgment, which starts on page 213 of the bundle. And if I could ask the court to look at paragraphs 59 and 60 and to read those.
Yes.
So, my lords, in this case, the Leasehold Reform Act said absolutely nothing about the public interest. And yet, despite that, Lord Justice Mummery, and we submit rightly, said that it would be wrong to allow the statute to be taken advantage of by someone who had created the conditions to claim the freehold by virtue of a deliberate breach of covenant. In the case of the Law of Property Act, Section 84, there is no need to imply a reference into the public interest because it is there. A covenant is only to be modified if it is operating contrary to the public interest. And the public interest includes the need to ensure, as Lord Justice Mummery put it, that people do not obtain a right by deliberately doing something that is necessary to found the claim, which act is wrongful as between him and the person against whom he seeks to enforce the right. Here, the right under Section 84 to have a covenant modified. We also draw attention to the well-known authorities on the principles for awarding an injunction, which we've cited in our written case. Lord McNaughton's guidance in the Coles case is quoted by Lord Newberger in Coventry and Lawrence as remaining useful guidance. That is in the main bundle at page 943. And at paragraph 121, at letter E, Lord Newberg says, I would cautiously, in the light of the fact that each case turns on its own facts, approve the observations of Lord McNaughton in Coles, where he said, in some cases, of course, an injunction is necessary if, for instance, the injury cannot fairly be compensated by money, if the defendant has acted in a high-handed manner, if he's endeavoured to steal a march upon the plaintiff or to evade the jurisdiction of the court. In all these cases, an injunction is necessary in order to do justice to the plaintiff and as a warning to others. But if there is really a question as to whether the obstruction is legal or not, and if the defendant has acted fairly and not in an unneighbourly spirit, I am disposed to think that the court ought to incline to damages rather than to an injunction. And then in the next paragraph, Lord Newberger said, the one possible doubt that I have about this observation relates to the suggestion in the ante-penultimate sentence that the court ought to incline to damages in the event he describes. If, as I suspect, Lord McNaughton was simply suggesting that if there was no prejudice to the claimant other than the bare fact of an interference with her rights, and there was no other ground for granting an injunction, I agree with him. However, it's right to emphasise that when a judge is called on to decide whether to award damages in lieu of an injunction, I do not think there should be an inclination either way. Subject to the legal burden discussed above, the outcome should always depend on all the evidence and arguments. And the key point there is that the conduct of the developer is an important consideration in deciding whether an injunction should be granted or not. On the one hand, there is the developer who acts in a high-handed manner. On the other, there is the developer who acts fairly and not in an unneighbourly spirit. And Lord Newberger clearly intends it to be understood that matters of that kind are to be taken into account and are highly significant. And that is not explained, but the obvious explanation is the strong public interest in encouraging good behaviour by developers and discouraging bad behaviour. And I should say that we've referred to a case called Ottercroft and Scandia Care, which I won't go to, but is in the main bundle at page 1255, where at paragraphs 13 and 14, Lord Justice Lewison quoted the first part of these observations and applied them. So in our submission, this guidance remains good law. And we have also in our written case referred to the very well-known case of Redland, Bricks and Morris, which is about mandatory injunctions. And in that case, again, it was said that reasonable behaviour is to be treated differently to unreasonable behaviour. And our submission is that since the need to encourage good and discourage bad behaviour by developers is a well-established feature of the public interest, it ought to feature in determining whether a covenant and impeding the use of land is operating contrary to the public interest. My learned friend has included in the supplemental bundle of authorities and referred to in his oral submissions a case called Buswell and Goodwin, which he says shows that these submissions I am making are incorrect. It does not. It concerned legislation which imposed on a housing authority a duty to close down houses which were both unfit for human habitation and which were not capable at reasonable expense of being rendered fit for human habitation. So that was an absolute duty imposed in the public interest. And once a closing order had been made, the effect was that the protection of the Rent Acts ceased to apply to a tenant in occupation. And the tenant who was in occupation said the only reason the closing order had been made was because the landlord had not performed his repairing obligations, which he had agreed he would carry out with the tenant. And the Court of Appeal said that although the principle that the person should not benefit from their own wrongdoing is a salutary one, it couldn't apply there in this case, because if it did apply, it would stultify and thwart the housing authority's duty, which was in the public interest, to close down premises which were unfit for human habitation and couldn't be made fit at reasonable expense. There is no...
There's obviously a spectrum of high-handed or cynical behavior, ranging from, well, we'll try and get planning permission without revealing that there's a restrictive covenant in place here, and without consulting the beneficiary of the covenant, down to positively concealing that there is a restrictive covenant. I mean, do you say that the tribunal's decision in this case as to the level at which the high-handedness occurred was not open to it?
My submission is the tribunal did not ask itself the right question at any stage, not when deciding whether there was jurisdiction and not when exercising its discretion. It did say that it was taking into account the conduct of the developer, but at no stage did it say, is it the conduct of the developer in building in breach of covenant that causes this application to succeed? In paragraph 106, it said that was not a question that arose, and at no stage did it address the question and determine it. The tribunal didn't seem to recognise, and my submission did not recognise, that that was the key question. The key point here was that the developer could not and would not have succeeded in its application if it had made it before committing the breach. It was only able to succeed because of its own breach, and that engages the principle which I rely on, which is that it is a matter of public interest. The person should not get an advantage by virtue of their own deliberate wrongdoing, the reason being to discourage people from deliberate wrongdoing.
Yes, Lord Kitchen.
You may say that this is a particularly clear case and that that is apparent from the judgments. But in many cases, it may not be apparent what the consequence would have been if the developer had behaved in a different way. So in those cases where the question is an open one, how is a tribunal meant to apply this this criterion that you're suggesting is relevant in considering the public interest issue under Section 84?
Well, this is a quite exceptional case. There is no similar case in the law reports. There is, in fact, only one case in the bundle of authorities in which the tribunal has held that a covenant did afford practical benefits of substantial value or advantage, but nonetheless decided to modify the covenants on the public interest ground. That is the SJC case that was originally taken to. In the other cases, the tribunal has said, well, there is no benefit to the persons who, no practical benefit of substantial value or advantage to the persons who have the benefit of the covenant, and it's also in the public interest to modify the covenant. So the Reed Lloyd case, for example, the Fisher and Gibson case, for example. Most of the cases that come before the tribunal are decided on the what Lord Justice Palmer called the limited benefit ground, the practical benefits of substantial value or advantage ground. And when public interest is mentioned, it's normally dealt with very briefly. So a case like this one, where it is clear that there were practical benefits of substantial value or advantage, it's also clear that the application would have failed if made before building and only succeeded because of the building. There never has been such a case before. And my submission, providing the Court of Appeal's judgment is upheld in this case, there will never be one again.
You say it's clear the application would otherwise have failed. I mean, is there a finding to that effect, or on what basis do you say that?
Well, perhaps I'm putting it slightly too highly. I would certainly say that on the tribunal's findings, it is likely that it would have failed because the tribunal said, I think it's paragraph 63 of the tribunal's document, if I remember correctly. I'll check on that. The tribunal said that it was apparent from the evidence that 23 units in affordable housing could have been provided on the unburdened land, which means there would have been no needs to breach the capital. So that was a finding the tribunal made. Perhaps the way I should put it is this: paragraph 62 on page 167. I think the tribunal was shown this by my learned friend this morning. Had it chosen to lay out the Exchange House site differently, it is likely that Millgate could have provided all 23 units in a single larger two-storey block of flats built entirely on the unburdened land. The local planning authority has indicated that it would have approved such a proposal, although whether housing solutions would have been content with it is not apparent. So I'm putting it too high, my lord, and saying it certainly would have failed. I can submit, though, that the tribunal did not address the question, said the question was not one that arose and it did not need to address its mind to. And in my submission, it certainly should have addressed its mind to it. And if it had done so, it is likely that it would have determined that the only reason the application was even argued was because of the developer's own deliberate breach. Our submission is that the public interest is promoted in leaving a covenant in place in circumstances such as this case, because it means that we'll have to face the court, and the court will decide. And the court has much wider powers than the tribunal. The court can grant an injunction, and we've included in the case, in the authorities bundle, supplemental authorities, page 278, a case called Mortimer and Bailey, which is an illustration of the court granting an injunction requiring a building to be taken down, where the developer, in that case, neighbours who were acting in breach of a restrictive covenant, proceeded in the teeth of objections rather than seeking to have it ascertained before they started work whether they were or were not entitled to go ahead. And the fact that the court can, and sometimes does, grant injunctions requiring buildings to be taken down is a strong encouragement to developers to behave in a neighbourly way rather than just steaming ahead. And the court, if it decides not to grant an injunction, has power to award damages in lieu of an injunction, which will recognise the benefit to the developer in what they have done. And it is also possible that the law may be developed so that in circumstances such as this, the court will order an account of profits. And we draw attention in our written case to my Lord Borough's book on remedies for torts, breach of contract and equitable wrongs, which is in the main bundle at page 1443. And my Lord Boroughs will know of this, of course, but for the benefit of the court. Lord Boroughs there reviews the cases where an account of profits has been ordered, particularly in intellectual property cases and breach of confidence cases, and suggests that there may be grounds for extending that to other situations, in particular where the interest protected by a covenant is non-financial, and there is a deliberate and cynical breach committed with a view to making money. Whether the law does or doesn't develop in that way, it's not something the tribunal can have anything to say about. The tribunal cannot grant an injunction, can't grant negotiating damages, and can't grant an account of profits. And we
yes, Lord Chief.
May I ask another question? To satisfy 1A, it must also be shown that money will be an adequate compensation for any loss or disadvantage suffered by that person. How does that bear on this analysis and the submissions you're making?
Well, the context for that part of Section 84 is, of course, an order modifying or discharging a restrictive covenant preventing some use of land. And it has been held that the compensation must be for reduction in the amenities enjoyed by the owner of the benefited land. It can't include any part of the benefit obtained by the developer in carrying out the development. So what the Supreme Court called negotiating damages in the one-step case can't be awarded. And adequacy of damages in this context means that if there is a person or persons who can be shown to have suffered a loss of amenities, they can be compensated by a money payment for their reduction in their amenities. There are some cases where money can't be an adequate compensation. There is an example in the bundle where the Court of Appeal upheld a decision of the tribunal saying that money couldn't be an adequate compensation in the case of a council that held the benefit of covenants not for itself, but for the purpose of looking after the public interest in the area. But if there are...
Could I ask this? I mean, might it be said that money is not an adequate compensation for the loss or disadvantage the person will suffer if they've lost the opportunity to negotiate the release with the developer before the development began?
Lord, I see the force of that. The difficulty it confronts is that the Court of Appeal has held, and has rightly held, that the loss or disadvantage, which is referred to in, let's get the section, so I don't misquote it, that the sum to make up for any loss or disadvantage suffered by that person in consequence of the discharge or modification is limited to the impact on the amenities enjoyed by the person and can't extend to the loss of the ability to negotiate a payment which includes the benefit to the developer. So, in fact, thinking aloud, your Lordship's point is a good one, providing it's remembered that the payment which can be negotiated is limited to a payment for the effect on the amenities of the benefited land. Providing that's been in mind, then your Lordship's point is, I would respectfully say, a good one.
Yes.
So the next question is, assuming the court accepts that these are matters which are inherent in the public interest, and in that respect I would point out that my learned friend this morning, when addressing the exercise of the discretion by the upper tribunal, said that what he said they were doing was balancing two public interests. In fact, in my submission they didn't do that, but the way that submission is put recognises the public interest in the matters I have been identifying, and that Lord Justice Sales identified far more eloquently than I've been able to do in his judgment. So once one has accepted that there is a public interest in the matters I have identified, then what ground is there for saying that those aspects of the public interest are to be ignored when considering section 84 1AB? If we could look at section 84 1B for a moment, in the main bundle at page 319. In determining whether a case is one falling within subsection 1A above, that is to say here, whether the covenant is contrary to the public interest, and in determining whether in any such case or otherwise a restriction ought to be discharged or modified, the upper tribunal shall take into account, and then a number of things are listed. So in our submission, what that makes quite clear is that the same factors are to be taken into account in deciding whether it is a subsection 1A case, and in determining whether the tribunal ought to make the order. And at the end of the list is any other material circumstances. And in our submission, the conduct of the developer in a case like this is one of the material circumstances. And subsection 1B specifically directs that it is to be taken into account as a material circumstance, both in deciding whether it is a subsection 1A case, and if so, whether an order ought to be made. My learned friend says this renders the discretion nugatory, but that is not the way that section 84 works. Section 84 cases have always proceeded on the basis that once the statutory grounds are made up, there needs to be a good reason not to make an order. And in fact, it's very difficult to find a case where the tribunal has held that it has jurisdiction to make an order, but has nonetheless not done so. My junior was able to find one where it was said that it would be wrong to make an order because the covenant had very recently been entered into by the very parties before the tribunal. But apart from that sort of exceptional case, the tribunal either says we do not have jurisdiction, so we will not make an order, or it says we have jurisdiction, we will make an order. There are a couple where the tribunal has said we don't have jurisdiction, and we might well not have made an order anyway in the exercise of our discretion. But that's as far as it goes, and that is because with a carefully structured and detailed provision like Section 84, it's unlikely that there will be many situations where the facts giving rise to the jurisdiction are made out, but nonetheless it would be right as a matter of discretion to refuse to make an order. My lord.
Can I just ask you in relation to that submission, what you would say about the other jurisdictional gateways? Because what you've told us so far is that there's a very important public interest in not allowing profiteering by cynical developers. But you're going to have to take that into account, aren't you, under the discretionary head when one's dealing with the other jurisdictional gateways?
Well, Lord, as I said, certainly as far as I'm aware, there aren't cases where the tribunal has said, apart from the one exceptional case I mentioned, which is very different to the facts here, but the cases where the tribunal has criticised the applicant for behaving badly, there is the Green case that I'm going to take the court to time around, where the member said there was no harm done by the conversion of the property into a mosque. It didn't cause any injury to anybody. And he said he wasn't happy with the way the developer had behaved, with the way that the people who were, they weren't really developers, they were people who owned this property and wanted to use it as a mosque, and they started using it as a mosque in breach of covenant. He wasn't happy with it, but he thought it would be penal to deprive them of their order simply because they'd gone ahead and started using the property as a mosque before he had determined the matter. And there's the Wimpy case, where the member held that the activities did deprive the persons with the benefit of the covenant of practical benefits of substantial value or advantage, so he had no jurisdiction to make an order. And he said that even if he had had a jurisdiction, he doubted he would have made it because the developer had behaved badly. And in my submission, in a case where the activities really don't cause any harm at all, or very little harm to the neighbour, so it's the limited benefit ground, subsection 1AA that is in play, the developer's conduct is most unlikely to have any real bearing on the outcome. And in those situations, it really would be penal to say, well, you're not doing any harm, but you started too early, so you're not going to get your order, which is why the decision in the Green case was undoubtedly correct. But what's different here is it's the developer's conduct in acting in breach of covenant that creates the public interest, which is then relied on as supporting the order. That's what makes this case so different to any of the others, in my submission. As far as the approach taken by the tribunal is concerned, the court has seen paragraph 106 of the tribunal's decision, where it said it was no answer to the current wasteful state of affairs to say that Millgate could have built their allocation of affordable housing on other land or could now buy its way out of the problem. And the tribunal said whether those would have been sufficient answers to Millgate's case on public interest if we'd been dealing with an application before any housing had been built on the site is not a question which arises. So certainly there they said it was an irrelevance, it was not a material consideration. And we say, and the Court of Appeal said, that is an error of law. My learned friend said that they did address it when dealing with the question of discretion. In my submission, they did not. If we could look at page 177 again, please, of the main bundle, and paragraph 113 of the tribunal's decision. I know the court has been taken through this by my learned friend, but in my submission, what he sought to get out of it just is not there. Paragraph 113 the tribunal said that Mr. Driscoll had submitted, there was no good reason for refusing modification. Paragraph 114, they said they didn't think there was as little to the issue of discretion as Mr. Driscoll had suggested, and they refuted a suggestion that a landowner who's in deliberate breach can confidently assume that the tribunal's discretion will be exercised in favour of modification or discharge. And they said that for two reasons. The first is the one given by Mr. Rose in the George Wimpey case, and that's the one where Mr. Rose refused the application because he said he had no jurisdiction, but commented that he might well have refused it anyway as a matter of discretion because Wimpey had behaved badly. So that's a sort of general indication that the sort of attitude the tribunal might take in a limited benefit type of case. And then at paragraph 115, the tribunal says that too great a readiness on the part of the tribunal to exercise its powers in cases where a development has already taken place would be liable to undermine the protection which restrictive covenants afford. And if it was thought to be easier to secure a modification in favour of a completed development than for one which had not yet commenced, the contract breaker would have a real incentive to press on, even in face of strong objections. Any developer who thinks in that way should think again or risk the mood awakening threatened by Mr. Justice Brighton. And then you might have thought at that point they would say, well, we will now consider whether that is the case here. But they didn't. They just stopped, which is why my Lord Burrows was right to say they did nothing more than pay lip service to this principle. They mentioned it, but they didn't apply it or even begin to apply it. What they did then was go on at paragraph 116 to say that the discretion shouldn't be used to punish a covenant breaker, and then they cited the Reed trustees of Green, Masjid and Madrasa's application, the one I have already mentioned. And one more point before I leave this. At paragraph 120 on page 178, the tribunal said that if they'd been persuaded on the limited benefit ground, they would have found the exercise of their discretion much more difficult than they did. In my submission, that just shows the error of thinking on the part of the tribunal. They seem to think it's more important to pay attention to the developer's conduct in a situation where it has made no difference and could make no difference because the development has no substantial bad impact on the neighbours, than in a case where it does have a substantial bad impact on the neighbours. And the only reason for even considering making the order is because of the state of affairs produced by the developer's deliberate breach. And if I could then go to the Green case, which is in the main authorities at page 603. Decision of Mr. Trott, one of the surveyor members of the tribunal, and it concerned land subject to a covenant limiting use to a private dwelling house or for the practice of a professional person. And the applicants wanted to use the land as a mosque and madrasa. And at page 629, we can go to page 629, please. At paragraph 121, the member concluded that the proposed modification will not adversely affect the value of any of the council's adjoining or adjacent property. Furthermore, I do not consider that the proposal will cause any disadvantage to the council, either as landowner or, if relevant, as a custodian of the public interest. So that was his conclusion on the facts. And so clearly the fact that the trustees of the property had started using it as a mosque precipitously made no difference, could make no difference to the outcome, because the fact is it just didn't cause any harm. And then page paragraph 126, he said, under section 84(1)(b), I am required to take into account any other material circumstances when determining whether the restriction ought to be modified. I'm invited by the council to exercise my discretion against the applicants due to their conduct in committing a willful and sustained breach of the covenant. The applicants consider that to refuse them relief, having established the tribunal's jurisdiction, would be wholly disproportionate and unduly harsh. And then he says that the applicants acknowledged their continuing breach. They explained that they thought that the fact that they had planning permission meant they could expect the council to modify the covenant, and he addresses questions of conduct. And then in paragraph 128, he says the applicant's conduct justifies Mr. Bates' description of it as someone chancing their arm, and says the conduct is to be deprecated. And then he refers to the George Wimpey case in another case, and points out that in both Wimpey and the Reilly's application case, the comments were obiter, since the tribunal found there was no jurisdiction for it to modify. But in the present case, I have found that I do have such jurisdiction. And it's in that context that he writes paragraph 129. Under these circumstances, i.e. where the development has taken place in breach of contract that has caused no harm to anybody, under these circumstances, a refusal of application as a matter of discretion invites the description of a sanction, trump card as Mr. Hanson described it, to overcome the council's failure to sustain a valid objection. And then he says it would be wrong to deprive their order unless the conduct is egregious and unconscionable, which he didn't think. He didn't think that the applicant's conduct was so brazen as to justify my refusal of their application. And we say that is clearly the right approach in a limited benefit case. Now, the fact that the development has gone ahead without an application to tribunal is regrettable, it's a bad thing, but it hasn't ultimately had any effect on the outcome. And the tribunal in the present case entirely failed to appreciate that this case was completely different, because it was the developer's breach of covenant in building the properties in breach of covenant that put it in the position where it could persuade the tribunal that the public interest was engaged. The next submission I make is one that
just as regards what you said about paragraph 129, you've given us a reason to distinguish that case from the case with which we're concerned, that is, that it's a different jurisdictional gateway. But isn't it also the case that the tribunal in that case was not satisfied that there was egregious and unconscionable behaviour?
That is also true. It follows from what the member said in the penultimate sentence that he thought the behaviour had been egregious and unconscionable. He might have taken a different course and thought it was right to withhold an order as a punishment. But in paragraph 130, he took account of two factors as mitigating the applicant's conduct. The first is that they weren't doing it for money, but for religious reasons. And the second was that they made a mistake in thinking that the fact that the council had given them planning permission meant that they would also give them permission under the covenant. So those are the two particular factors in that case.
Yeah, so what I'm driving at is the comment on balance, I don't consider that the applicant's conduct was so brazen as to justify my refusal of their application, might be regarded as a distinction from our case, might it not?
Yes, indeed. Marlena Jr., who presented the case in the upper tribunal, did submit that Bill Gates' behaviour had been egregious and unconscionable. And the reaction of the tribunal to that was to say they had taken all her submissions into account and the conduct of the developer into account. They didn't say whether they did or did not consider the developer's conduct as egregious, and they didn't say whether they thought it was unconscionable. They just said they had taken it into account. So yes, in my submission, that is right. But ultimately, what I'm submitting is that saying no in a situation like the present isn't to use the discretion as a punishment at all. It's to use it for the purposes that Lord McNaughton explained in the Coles case, to do justice to my clients and to deter other people from behaving in the way that this developer behaved, and to avoid the very problem that the tribunal recognised and paid lip service to, but didn't in any way reflect in the exercise of its discretion.
Of course, egregious and unconscionable are relative terms. I mean, do you submit that there is no instance of behaviour properly described as egregious or unconscionable, where it would be proper for the tribunal to allow the the application to proceed.
My submission is it's right to say that Lord Justice Sales was not particularly happy about that phraseology in his judgment. In paragraph 84 of his judgment, which is page 150 of the bundle, he said he didn't find those epithets particularly helpful.
No.
And, I'm certainly not suggesting that they're the right epithets to apply. The test I invite the court to apply is whether there is a nexus between the unreasonable behaviour, I will use that expression rather than more extremely, whether there's a nexus between the deliberate breach of covenant and the facts which are relied on to obtain the order. If there is no nexus at all, there's no connection between the deliberate breach of covenant and the circumstances that give the tribunal jurisdiction, it would be a punishment to say, we're not giving you the order because of your bad behaviour. But if there is a nexus, then it's simply applying a well-established principle that as a matter of public interest, the person ought not to be in a better position as a result of their deliberate wrongdoing than they would have been if they hadn't committed the wrongdoing.
Yes. Right, well, we better move on, hadn't we?
Indeed. The next topic I wanted to address was one that wasn't addressed by Lord Justice Sales in his judgment. In my submission, it does give strong support to the principles that he laid down in his judgment. But if I'm wrong about that, it certainly doesn't undermine those principles. If I'm right, it helps. If I'm wrong, it's an irrelevance. And that is the established position in relation to powers of compulsory purchase. My learned friend says that powers of compulsory purchase are completely different to Section 84. In my submission, they're not completely different, they're very similar. A restrictive covenant is a property right, and that's been settled law ever since the leading decision of the Court of Appeal in the Green-Nisbet and Fox contract, which is in the bundle at page 1219. It's analogous to a right to light or a right to air or a right to the flow of water from neighbouring land. It is the right to prevent things from happening on neighbouring land that have a bad effect on one's own land. And like an easement, easements can be acquired by prescription. Restrictive covenants are only created by agreement. But that is a distinction that doesn't matter here. What matters here is it is a property right. It is for the benefit of land and is part of the property owned by the person who has the benefit of the covenant. And the effect of Section 84 is to override that. And that is the reason that the practice directions of the Upper Tribunal made by Lord Justice Carnworth, who was the senior president of tribunals, have a special costs rule in the case of Section 84 applications. And that's at page 1529 of the main bundle. There are a number of special rules that apply in the Upper Tribunal, otherwise the normal rule applies. But under 12.5 in the practice direction, sub-rule 3, with regard to the cost of the substantive proceedings, because the applicant is seeking to remove or diminish particular property rights that the objector has, unless they have acted unreasonably, unsuccessful objectors to an application will not normally be ordered to pay any of the applicant's costs, and successful objectors will usually be awarded their costs, unless they've acted unreasonably. So this is a statute that gives a power to a tribunal to take away or greatly reduce property rights. And in the case of the public interest ground, we are considering a situation where the right in question is not obsolete. The owner of the land hasn't agreed to it being taken away. It does afford practical benefits of substantial value or advantage. Modifying it will injure him, and yet nonetheless it is being said that it is in the public interest. It would be contrary to the public interest to allow him to continue to enjoy his property undisturbed, and he is to be paid compensation which reflects only the reduction in his amenities and not the benefit to the developer. That is a classic example of the right of compulsory purchase in my submission, and therefore the principles that have been laid down over many years which apply to compulsory purchase legislation do apply. I can just show the courts the main authority I rely on this court. It's page 521 of the main bundle. It's a case called the Queen Sainsbury's Supermarket against Wolverhampton City Council. It concerned a site in Wolverhampton known as the Raglan Street site. Sainsbury's owned 86% of the Raglan Street site and Tesco owned 14%. They both wanted to develop it. They couldn't cooperate or wouldn't cooperate. Council therefore had to choose between them and compulsorily purchase one or the other's interest. And they chose Tesco. And the reason they chose Tesco, even though it only owned 14% of the site, was this. Tesco owned another site about half a mile away called the Royal Hospital site. And the council was very keen to see that other site developed. But Tesco said it would be too expensive unless it could develop the Raglan Street site. And so the council made a compulsory purchase order in respect of Sainsbury's interest under section 226 of the Town and Country Planning Act. And Sainsbury's successfully challenged that on the ground that was wrong in law for the council to have regard to Tesco's commitment to develop the Royal Hospital site. The statutory provision under consideration is at page 530, paragraph 7. This is in the judgment of Lord Collins, who gave the leading judgment. Lord Walker, Lady Hale, and Lord Mansell agreed with him. The three other judges dissented wholly or in part. So, paragraph 7, Lord Collins quotes the relevant legislation, section 226 of the 1990 Act. A local authority to whom this section applies shall, on being authorised to do so by the Secretary of State, have power to acquire compulsorily any land in their area if the authority think that the acquisition will facilitate the carrying out of development, redevelopment or improvement on or in relation to the land, or which is required for a purpose which it is necessary to achieve in the interests of the proper planning of an area in which the land is situated. So the court had to interpret that and apply it. And at page 530 in paragraphs 9 to 11, Lord Collins explained the principles that apply. And perhaps I can invite the court to read paragraphs 9, 10 and 11.
Yes.
So, in particular, paragraph 11, when Lord Collins quotes from the Australian case, he says, right at the end, where a statute is capable of more than one construction, that construction will be chosen and interferes least with private property rights. And my learned friend says that doesn't apply to section 84. In my submission, it does apply to the public interest ground, and that is, I suggest, why Sir Douglas Frank, who was very experienced local government and planning barrister before he became the president of the Lands Tribunal, said that in approaching the public interest ground, there needed to be great care taken before overriding property rights that did confer practical advantages of practical benefits of substantial value or advantage in the public interest. One aspect of the principle that compulsory purchase powers should only be taken when it is decisively necessary in the public interest is that acquiring authorities have to try and acquire the land by agreement before they can apply for compulsory purchase powers. We've included cases that make that clear. I don't have time to go to them, but I refer the court, if I may, to the Margate Town Centre case, which is in the main bundle at page 1137. And the relevant passage is at page 1142. And we've also included the government guidance on compulsory purchase orders, which is in the main bundle at page 676, where it is said that a government department, before upholding compulsory purchasing will expect the acquiring authority to demonstrate that they've taken reasonable steps to acquire all of the land and rights included in the order by agreement. And this material supports in our submission the Court of Appeal's view that there's an important procedural dimension to the public interest. That before seeking a compulsory right to interfere with somebody's property, we should try and negotiate and act in a reasonable and neighbourly way. My learned friend says this is impractical for a developer who's proposing to develop in breach of a covenant in a way which is going to have a really bad effect on the neighbour, to try and find out who has the benefit and try and talk to them about what they're proposing to do. We reject that submission. That is plainly wrong. There's nothing impractical about it at all. The learned friend said the terms of insurance policies can cause difficulties. Well, there's no evidence of that. There is, in fact, an insurance policy in the present case, but it wasn't put in evidence. And if that is what insurance policies say, well, they shouldn't prevent developers from trying to behave in a reasonable and neighbourly way. The learned friend says this will encourage litigation. It will do quite the opposite. If a developer behaves responsibly and treats people with respect and their property rights with respect, it's much less likely to lead to litigation. If a developer can't find out who has the benefit, and that does occasionally happen, or nobody responds when the developer tries to contact them, then they can get insurance and they can proceed, and nobody will be able to criticise them for doing so. Lord Justice Sales makes the point in his judgment that in that situation, if the developer is unaware of a covenant or can't find out who has the benefit of it and does proceed, then that's a quite different situation to the one that we have here. My learned friend says, well, correspondence has to be conducted on a without prejudice basis. Well, no, it doesn't. The proof of that is the present case, when the developer made an open offer and the tribunal took it into account. There may be rare cases where there is a pressing public interest in works being carried out urgently, and it's not possible to get the consent of the benefited owners. Well, there is a procedure that was established many years ago. It's the Greenwich NHS Trust and London Quadrant case, which we put in the main bundle at page 1089. That was the case where an NHS trust needed to divert a road, and it needed to know it could do so without being subject to an injunction. And within 3 weeks of issuing a writ, it had a declaration from Justice Lightman that if it proceeded to divert the road, the only remedy anybody would be entitled to would be damages. There was no prospect of an injunction being granted. It is true, of course, that a Section 84 application can be made after a claim has been made for an injunction to restrain the breach. It's also true that Section 84 makes it clear that the upper tribunal has power to direct investigations, including by advertisement, to be made to ascertain who has the benefit of the covenant. That's just as much a part of the structure of Section 84 as the ability to apply after proceedings have been brought to restrain a breach. Neither of those matters really takes the matter much further forward. One shows that it is intended that the developer should make every effort to see who has the benefit of the covenant. The other shows that the mere fact that enforcement action is being taken doesn't prevent a Section 84 application being made and being successful. Neither really sheds any light on the situation here. So the next topic I wanted to turn to was the question of whether the Court of Appeal was right in saying that in other respects, apart from the one I've been addressing so far, the upper tribunal made errors of law. The first has to do with Lord Sumption's remarks in the Coventry and Lawrence case. And the tribunal, the court's already been shown what the tribunal said about that. Lord Justice Sale's reading was that the tribunal had regarded Lord Sumption's comments, obited comments, on what might be the way the law might develop in the future in relation to the tort of nuisance, as providing a parallel, in other words, as guiding the tribunal in the proper approach to the public interest ground under Section 84. My learned friend doesn't seek to say that Lord Sumption was right. He doesn't seek to say that Lord Sumption's approach ought to have been applied or the tribunal was right in following it. He says it played no part in the tribunal's thinking. And our submission is that no fair reading of the tribunal's decision could leave you with an impression that it played no part in their thinking. It is clear that it played a part in their thinking. When they said there are obvious parallels, what they meant is we're going to proceed on a parallel course to an assumption. And they didn't refer to what Lord Newberger said, they didn't refer to what Lord Matt said. Lord Justice Sales has given a number of powerful reasons in his judgment why Lord Sumption's comments are simply not applicable here. And in our submission, they clearly did influence the tribunal and wrongly influenced the tribunal, and that was a matter of law.
So, George, what do you say about paragraph 107 and the application of the Collins test, where they say that it's not necessary to to depart from that on the basis of Lawrence of Fenn-Tigers?
Well, what they said there was that they were mindful of what Sir Douglas Frank had said in Reed Collins. In my submission, Sir Douglas Frank was quite right in what he said in Reed Collins for reasons I've already attempted to explain.
Yes.
Then they said, well, it may require reconsideration, but it's not necessary to pursue that forward. And then they said, we're satisfied that the public interest in play in this case is sufficiently important and immediate to justify the exercise of the tribunal's power. And
so they're applying the Collins test.
They were saying that they thought that assuming the test applied, this case satisfied it, yes.
Yeah.
I accept that. But when Lord Justice Sales said they should have applied it, what he meant is the decision they actually reached was quite inconsistent with what Sir Douglas Frank had said. He wasn't saying they hadn't paid lip service to it. He was saying they'd only paid lip service to it. They said that they were applying it, but they clearly didn't, because of the reasons that Lord Justice Sales gave in his judgment. The part where Lord Justice Sales says they should have followed it is not where he's identifying the errors the tribunal actually made. It's where he's introducing the part of the judgment where he explains those errors. But what I do submit is that in the earlier part of the decision, particularly at paragraph 199, where they say there are obvious parallels, and paragraph 100, where they quote without any comment Lord Sumption's description as being unduly moralistic, the idea that nuisance should be injunctive. There's no suggestion there that they're regarding those as mere submissions that were made to them that played no part in their decision making. It's anybody reading this would come away with the impression they thought Lord Sumption was right and they were going to apply by way of parallel what Lord Sumption had said. That's what Lord Justice Sales said. And the Court of Appeal, or the member of the Court of Appeal agreed with him. We submit that's clearly correct. The next problem which Lord Justice Sales identified is the one in paragraph 102, and we submit that is a serious error, and indeed is quite inconsistent with the previous jurisprudence of the Upper Tribunal and Man's Tribunal. What the tribunal did here was treat one-off planning permission as being equivalent to the development plan, or equivalent to a declared pattern, the grant or refusal of planning permission, or an ascertainable pattern. And they said that this one-off planning permission reflected an objective assessment of appropriate land use. That is not the way that this matter has been approached before by the tribunal, and it's wrong. A development plan is a set of documents which are produced by a local planning authority after substantial consultation with the public. It is then submitted to a planning inspector for independent scrutiny. We've supplied more information about this in the form of the Encyclopedia of Planning, which is in the main bundle at page 1478, which explains in more detail what the development plan is. But essentially it is, and always has been, a set of documents that tell you what the local planning authorities proposals are for the development of its area, and which is subject to independent scrutiny. A declared pattern clearly means something that the local planning authority has said as a matter of policy it wants to see happen in the future. Typically that is done by what is called the supplementary planning guidance document, which is supplementary to the local plan and says in this particular area, this is the particular pattern of land uses that we consider are in the public interest. An ascertainable pattern, the planning permission speaks for itself. It's not a one-off planning permission, it's a series of planning permissions which have been granted and haven't been challenged or have been unsuccessfully challenged. But here we're just concerned with a single planning permission. Planning permissions can and sometimes are granted in error. The planning court has on numerous occasions quashed planning permissions granted in error. But there are many planning permissions that are granted in error that never see the inside of the planning court. With a 6-week time limit, you have to get leave. It's a long and expensive process. So just because a planning permission has been granted really doesn't tell you anything. It certainly doesn't tell you that it would be contrary to the public interest to prevent the development from going ahead because there's a restrictive covenant prohibiting it. The correct approach in our submissions would be in other cases. The first is the Reed-Bass case, which is at page 801 in the main bundle. And if we go to page 803 in this decision, and to question 5 on page 803. Question 5, is impeding the proposed user contrary to the public interest? And Mr. Daniel QC, if we can skip the first 2 sentences and start about 5 lines down with the words, as I have just said. As I have just said, a planning permission is immediately persuasive on the general question whether a user is reasonable. Mr. Eyre submitted that prima facie a planning permission also meant that the proposal was in the public interest, but that is not the question. The question is whether impeding the proposal is contrary to the public interest. And there is here more than a narrow nuance of difference. The planning permission only says, in effect, that a proposal will be allowed. It implies perhaps that such a proposal will not be a bad thing, but it does not necessarily imply that it will positively be a good thing and in the public interest, and that the failure of the proposal to materialise would be positively bad. Many planning permissions have got through by the skin of their teeth, and I think that the assistance derived from a planning permission at this stage of things is little more than the negative assistance of enabling it to be said that at any rate there was not a refusal. Thus the proving that impeding the present proposal was contrary to the public interest raises a different onus from the onus of proving the user to be a reasonable one. This is really obvious from the drafting of the section, but I have spelled it out in the present case because I think it is necessary. Then he goes on to say that although the proposed user was reasonable, to stop it wouldn't be contrary to the public interest. And the same approach was taken in Reed-Collins, which is page 357. And the relevant part starts at page 358. The top. Sir Douglas Frank records that the application was to enable 30 detached dwellings to be erected in accordance with the planning permission granted in 1972. And then at page 360, question 5, is impeding the proposed user contrary to the public interest. Mr. Glover relied upon the following published documents, and he lists a number of published documents: a Southeast study, a strategy for the Southeast, government white papers and circulars, a development control policy notes, a town map, an interim plan, and the local plan. And then he says, near the bottom of the page, the purpose of producing these documents is to show that there's a shortage of land available for building houses in the Southeast. Published plans provide for some of the deficiencies to be met in the outer metropolitan area in which Fleet is situated. The sites for subject to these applications are allocated in the approved development plan, that is the town map for residential development. It's county council policy that the sites will be made available for development. and that it's government policy to encourage development of high densities. Then he doubts whether any of them, apart from the approved development plan, are admissible. And then he quotes from section 84. And eventually he concludes about halfway down the page, I hold that all these documents other than the approved town map are inadmissible. But even if I'm wrong, I do not think that they advance the applicant's case very much. Nobody is objecting to the residential development of the application sites. The only issue is how many houses. And then at the end of the page, he has the comment that was quoted in our case, that for an application to succeed on the ground of public interest, it must be shown that the interest is so important and immediate as to justify the serious interference of private rights and the sanctity of contract. In my judgment, this case comes nowhere near satisfying that test. So he says that the mere fact that a planning permission has been granted doesn't take you very far. It shows it's a reasonable use, but it doesn't show that prohibiting it would be contrary to the public interest. And again at page 1249, if I may. This is a case called Re Osborne and Easton's application. And tribunal, about halfway down the page, I now turn to the other limb relied on by the applicants. And it says, I now turn to the other limb relied on by the applicants, namely public interest. There can be no doubt that it is the government's policy and has been for some time to encourage the development of building land at the highest density, which in the circumstances is reasonable, and to provide more homes to small households. Grant of planning permission by the Secretary of State in this case is strong evidence that in his view these sites are suitable for the implementation of the policy I've described, and to that extent that the development would be in the public interest. But it seems to me one thing to say that the development is in the public interest, and another that it would be contrary to the public interest if the development did not take place. And then he goes on to explain that further. And then if we go to page 473, this is another tribunal case. This time it's called Re Martin's application. This time the member was Mr. Wellings QC, and this case was slightly unusual because the restrictive covenant wasn't in a conveyance, it was in what would now be called the Section 106 agreement, an agreement with the planning authority. And the relevant part of the decision is at page 481. Two paragraphs down. As to paragraph AA, the decision of the inspector and his grant of planning permission do no more, in my judgment, than demonstrate that the construction of the new house would be in the public interest. They do not determine that the restriction in impeding legal use would be contrary to the public interest, having regard to the circumstances and more particularly to the cramped appearance which a new house would give. I determine that question in the negative. And in this case, there was an appeal, which is page, the next page in the bundle, page 482 is where it begins. An appeal to the Court of Appeal, which was dismissed. And at page 487, towards the bottom of the page, in the judgment of Lord Justice Fox, does the court see the paragraph beginning basically? It's about 2/3 of the way down that, where Lord Justice Fox said, thus it seems to me that while the two regimes impinge upon each other to some extent, they constitute different systems of control, and each has and retains an independent existence. In my view, the applicant's contention is wrong insofar as it suggests that the granting of planning permission by the Secretary of State necessarily involves the result that the Lands Tribunal must discharge the covenant. The granting of planning permission is, as it seems to me, merely a circumstance which the Lands Tribunal can and should take into account when exercising its jurisdiction in Section 84. To give the grant of planning permission a wider effect is, I think, destructive of the express statutory jurisdiction conferred by Section 84. It's for the tribunal to make up its own mind whether the requirements of Section 84 are satisfied. The grant of permission by the Secretary of State is no more conclusive than that is, for example, the deemed grant of planning permission under the provisions of the General Development. So the approach of Mr. Wellings in that case, which accords with the approach of Mr. Daniel and Sir Douglas Frank in the previous cases I've taken the court to, is all repeats. Namely, that the grant of planning permission does establish that the proposed use is a reasonable use of land, which is why in virtually every case, certainly every case in the law, planning permission is obtained before a Section 84 application is made. Indeed, if you didn't have a planning permission, it would be difficult to say that the covenant was impeding the proposed use of land because you might not get planning permission, in which case the covenant would be an irrelevance. But the mere grant of a planning permission doesn't tell you that the proposed development is sufficiently important for it to be contrary to the public interest to enforce the covenant and prevent the development from going ahead. So the tribunal in this case took a completely different line to many tribunals that run all this. I can't hear you, Lordship.
In relation to this submission, could you just help me by pointing to where the Court of Appeal regarded this as an error of law?
Of course. Give me 1 moment. Paragraph, it's page 142, paragraph 55. Lord Justice Sales refers to the balance, and he puts part of what I showed before, but not the part which where Mr. Daniel said that some planning permissions get through by the skin of their teeth. And then at paragraph 56, he says the grant of planning permission is not at all the same as upholding a restrictive covenant which impedes some reasonable user.
Yes, thank you.
And then also at the end, he says, let's just check. Yes, it's paragraph 68, my lord, page 146. The upper tribunal has in two respects failed to apply section 84(1)b correctly when arriving at its conclusion. The first respect again relates to the improper weight which the upper tribunal gave at 102 to the grant of planning permission. The upper tribunal treated section 84(1)b as supportive of its view, but it was not supportive. The development plan placed the application land in the green belt, thereby indicating that there was the usual strong presumption against its residential development, as proposed by Millgate. The upper tribunal did not identify any declarable ascertainable pattern for the grant or refusal of planning permissions in the relevant area, let alone one which supported Millgate's arguments regarding the public interest. So certainly we submit Lord Justice Sales considered, and we submit rightly considered, that the tribunal treatment of the planning permission was wrong in law, and Lord Justice Farnworth said in Shepherd and Turner that unexplained inconsistency can be an error of law. And for the tribunal to take such a different approach to a one-off planning permission to the predecessor tribunals is itself worrying. And in our submission, what section 84(1)b is directing to is matters which indicate general policies and not one-off decisions. The actual planning permission in the present case was in evidence. It's at page 1559. It was given the reference 13-01946, was for the erection of 23 dwellings, and page 1565, towards the lower half of the page, in the middle of the page, there is a justifications heading, and that says the reason planning permission has been granted is that the road development represents inappropriate development in the green belt. Contrary to the provisions of the development plan, the applicant has demonstrated that very special circumstances exist in this case to justify the development proposed. These very special circumstances are that the development will enhance the character and amenity of the area and is suitable for the character of the area, as on previously developed land, will improve the access to and relationship with the approved hospice, and is sensitive to adjoining uses. The proposal is compliant with the national planning policy framework. The relevant policies of the development plan are given. The development plan itself was not in evidence. There was no evidence of any declared pattern of planning permissions. There was no evidence of any ascertainable pattern of planning permissions. It was just this one-off permission with this justification section in it. It was put in support, and also put in by Millgate with a letter which is a
Right. So I'm sorry, do forgive me. That's my fault.
Sorry, Lord.
Do continue.
Thank you, my Lord. Page 1595, if I may. This is a letter that Millgate put in evidence. It's from the planning officers at the Royal Borough of Windsor and Maidenhead. And it is a letter in which he says that he considers that building 24 apartments on the unburdened land would be acceptable. And at the bottom of the page, she says, under the heading, whether the proposal is appropriate development in the Greenbelt, and if not, whether very special circumstances exist for allowing it. With regard to impact on the Greenbelt, officers consider that this scheme offers real benefits with regard to impact on the Greenbelt. The previous scheme, which is the one that was actually given permission, was recommended for refusal by officers on impact on the Greenbelt. And she then goes on to explain why it's much better from a Greenbelt point of view for all the buildings to be put on the unburdened land than for some of them to be put on the burdened land, which makes perfect sense. So what little we know about the grant of this planning permission is that it was given contrary to the development plan, against the advice of the planning officers, and for what reasons we don't know. That is no basis at all for the tribunal to say that this one-off planning permission should be given the status of the development plan, or a declared pattern of planning permissions, or an ascertainable pattern of planning permissions. That was wrong in law, and Lord Justice Sales was right so to hold. The next submission relates to the £1,639,000. And if the tribunal could please go to page 165. In paragraph 53 of the tribunal's decision. The tribunal said, since making the application, Millgate has negotiated an alternative arrangement with the local authority, under which it is entitled to make a payment of £1,639,904 in return for a release from its undertaking, thus allowing the local authority to provide equivalent affordable housing elsewhere. So that was the finding of fact by the tribunal, which was quite correct. The variation agreement is in the bundle of page 165, paragraph 53. Sorry, it's in the bundle of page 295, but it's not necessary to turn it up. It said that Millgate could make that what was called an affordable housing contribution in lieu of the provision of 13 units of affordable housing. And at page 1597, if I may please. This is an email from Jill Caress at Housing Solutions to Victoria Gibson, who is the planning officer who wrote the letter we looked at a moment ago. Hi Victoria, I hope you're well. Nick Jackson of Millgate forwarded to me the letter from Kempton Carcroft, categories of reference suggesting a possible way forward in the event that the remaining units at Exchange House cannot be transferred to Housing Solutions. I've read the suggested contribution could possibly be applied to a do-it-yourself shared ownership scheme, such as the one we're currently running in partnership with the borough. I confirm that on the existing scheme, were receiving grant from Section 106 funds to enable housing solutions to purchase properties which have been selected by our applicants and simultaneously we sell the applicant a share of the equity of the property. The amounts vary from purchaser to purchaser and the size of the property they need. But we received £1,860,000 in grant, and this is funding 32 purchases ranging from one-bed flats to three-bed houses. A typical purchase of a three-bed house requires subsidy of around £65,000 to £70,000, and therefore the sum of £500,660 should easily fund over 4 units, even with property values rising. My first submission is that it was for the developer, it was for Millgate to produce evidence in support of its contention that the covenant was operating contrary to the public interest. It wasn't for my client to do that. So to the extent that there is a lack of evidence about how quickly it would be possible to provide new housing using the £1.6 million, where that housing would be provided, how good the housing would be, and so on. Those were all matters that Millgate could have put in evidence. It wasn't for my client to do it. But my second submission is that based on this email that was put in evidence, it is clear that the contribution was to be used not to build new properties, but to buy existing properties. And what is more, that the existing properties would range in size and would reflect the needs of the purchaser concerned. And one can see immediately that there are advantages in proceeding in this way from the point of view of people who are waiting for housing. They might have to wait a little longer, but they would get to choose exactly the property they wanted in the place they wanted it and get a substantial financial contribution which would enable them to buy it. The Upper Tribunal paid no attention at all to this. It said it wasn't relevant in paragraph 106. It is no answer to the current wasteful state of affairs to say that Millgate could buy its way out of the problem by making a payment towards the provision of social housing elsewhere. But it was an answer. To the extent the tribunal was concerned about the people who were waiting for affordable housing, this was a perfectly acceptable answer. The local authority thought it was acceptable, which is why it varied from Section 106 agreement. Housing Solutions thought it was acceptable. If one puts oneself in the position as far as one can of somebody who is waiting for housing, you have a choice of being told you have to go to the exchange house site and take one of the properties there, or being able to choose a property that suits you, a place that suits you, and get a substantial financial contribution towards buying it. Which would you prefer? And the answer is far from obvious. It isn't necessary for me to answer the question. All that's necessary for me to submit, and do submit, is the Upper Tribunal paid no attention to this point, treated it as one of no relevance at all, and that was a further error of law. There was no evidence of shortage of housing, no evidence of difficulty of finding properties in the area, no evidence that the public interest required the affordable housing to be on this particular land rather than somewhere else. And without that sort of evidence, it was not open to the tribunal to simply ignore this and say it was irrelevant. I could ask the tribunal to look at page 322. This is one of the cases that we have referred to in our written case. It's called in the matter of an application by Adnan Afsar, another decision by Mr. Rose. It was a case where an application was made to modify a dwelling house only covenant to permit the use of the property as a residential home for the elderly, for which planning permission had been granted. And if I could ask the court please to go to page 333. And if I could invite the court please to read paragraphs 45, 46 and 47.
Yes.
So that is the established approach that the tribunal takes, where it is said there's some particular use that the applicant wishes to make of the subject property. The use may be in the public interest, but it needs to be shown that this is the place where it needs to take place. There is nowhere else suitable for it to take place. Otherwise, it isn't contrary to the public interest for it not to happen on the application land. It can happen somewhere else. And in the present case, the evidence made it clear that satisfactory affordable housing would and could be provided for people who needed it elsewhere if the £1.64 million was paid. Certainly there was no evidence the other way, and it was incumbent on Millgate to produce such evidence if it wished to make anything of this point. Therefore, in our submission, Lord Justice Sales was quite right in paragraph 72 of the Court of Appeal's judgment to say that the tribunal, having treated the provision of affordable housing as relevant to the public interest issue, left the possibility of provision of that same amount of affordable housing by the alternative means that have identified out of account, even though these alternative means of provision would have meant that this aspect of the public interest could be satisfied without the need to override the restrictive covenants. The final submission is that the Court of Appeal was also right in saying that even setting aside these individual errors, which Lord Justice Sales identified and which I have attempted to support, if you look at the tribunal's decision overall, it was simply one that no reasonable tribunal could have arrived at on the facts of this case. Facts where the tribunal either knew or could easily have found out who had the benefit of the covenant, where at an early stage, because they've done much building, they're approached by somebody who has the benefit of the covenant and asked to stop, where they're told about the likely impact on the hospice, just plough on ahead regardless, and then only make the application to the tribunal once the property is complete. And it is putting the matter at its lowest possible, but quite different result would have been arrived at had they made an application before they breached the covenant. And I would say it's clear from the tribunal's decision that it is at least likely, if not certain, that the only reason the developer succeeded was because of the state of affairs produced by their own deliberate breach of covenant. And in those circumstances, in our submission, Lord Justice Sales was quite right to say the only reasonable conclusion that a reasonable tribunal could arrive at is to reject the application. My learned friend says Lord Justice Sales didn't use the Edwards and Bairstow language. But my learned friend quite rightly says that when reviewing a decision by an experienced judge, you should assume that they've correctly directed themselves in law, unless it's clear that they haven't. And that should apply just as much in favour of Lord Justice Sales as it does in favour of the upper tribunal. Lord Justice Sales, when at the bar, was an administrative lawyer. He knows the right test to apply on an appeal of this kind, and find the approach taken by the House of Lords in the AH Sudan and SSHD case that my learned friend relies on to find that approach here. It should be taken that Lord Justice Sales correctly understood what he was doing when he said the tribunal was wrong. He meant they had arrived at a decision that no reasonable tribunal could have arrived at on these facts. So may I just check one thing before I...
Yes, Lord Kitchen.
I've got one question I would be grateful for your help on, and that is this. Assume that the order sought had been refused. How satisfactory is it that this whole issue should have to be gone into again before a judge upon an application to enforce the restrictive covenant? What troubles me is you're going to have all of these proceedings. The application will be refused. The application is then made to enforce the covenant. And at that point, all of these arguments are going to be wheeled out again.
Well, I see the force of that. It is a problem which exists not only here, but in many other landlord tenant settings where the Parliament, in its wisdom, has chosen to give one set of jurisdictions to a tribunal and a different and parallel set of jurisdictions to the court. It happens in enfranchisement cases, for example. And a practical solution which exists today is to make an application to the court and to the tribunal and seek to have them case managed and tried by somebody who is qualified to sit both as a member of the tribunal and as a judge of the court. That can be done, that has been done. It's called double patting. And it's been done in service charge and enfranchisement cases. So there's no reason why it couldn't be done in restricted covenant cases, and one can see strong practical advantages to doing it. So that is the solution for the future. It would have been open to Millgate in the present case to have both applied under Section 84 and made a Greenwich type application to the court for a declaration that if the Section 84 application was unsuccessful, the appropriate remedy would be damages rather than an injunction, and the two could have been heard together. But that isn't what happened here. Perhaps it should happen in the future, which would be the solution. The problem is created by Parliament's decision to leave injunctions and damages to the court and give this jurisdiction to the tribunal.
Thank you.
Yes, Lord Barrows.
You said that we're to read Lord Justice Sales as in effect applying the test that no reasonable tribunal would have arrived at this decision. But what about the actual words that he used at paragraph 77, which is that insufficient weight was placed on the developer's conduct, or words to that effect? I mean, are you suggesting that we regard that as a correct formulation of the test?
My submission is that, as in the AH Sudan case, where Lord Bingham said at some points it looked as though the tribunal had misdirected itself, one should bear in mind the improbability of an experienced tribunal, in this case the Court of Appeal, making a fundamental, really basic error. I mean, for the Court of Appeal to misunderstand a test it's supposed to apply when hearing an appeal from a specialist tribunal is pretty unlikely. And my learned friend has accepted that, rightly accepted that Michael Driscoll QC, the late Michael Driscoll QC, in his skeleton argument right at the very beginning, actually drew attention to the correct principles for the tribunal to apply. That is, I think, if I remember rightly, right at the end of the hearing bundle. It's page 1605, my lord.
Thank you.
So, in his skeleton argument right at the beginning, Mr. Driscoll drew attention to the fact that the court could only act on an error of law. He said, an appeal to the Court of Appeal from the Upper Tribunal was only available on a point of law, see Section 13 of the 2007 Act. And then at paragraph 2, he set out the principles that my learned friend rightly says apply to this sort of appeal. So, is it possible that Lord Justice Sale, despite his vast experiences as an administrative lawyer, despite being specifically reminded in this skeleton argument of what he should be doing, did something wrong? It's just about possible, but it's very, very unlikely. And applying the AH Sudan approach, one should say no, he didn't. And when he was talking about weight, he was saying no reasonable tribunal could have reached a decision applying the weight that this tribunal did.
Well, it's a slightly curious way of putting it, Mr. Good, but there it is. I think you've probably taken it as far as you can.
I think I may have said as much on that subject as I'm able to say. May I just see if there's anything I should have said that happened? No, I've said enough. I've certainly used up my time, so thank you very much, my lord.
Thank you very much indeed, Mr. Good. Now, Mr. Hutchings.
My lord, thank you. Lord, can I just first of all deal or pick up perhaps on Lord Kitchen's last point? So I think it's a very valuable one, that the reality is that if the tribunal's decision is overturned, or at least if the Court of Appeal's decision rather is not overturned, that it will be a situation where matters have to be gone into all over again. My learned friend suggests that we could make an application together with an application to the High Court under, I think he called it the sort of Greenwich NHS Trust jurisdiction. But what application would we make? My learned friends suggest we would make an application that in the event that the injunction is the application is unsuccessful, that we would then move on to a High Court trial about whether or not an injunction or damages should be granted. But why would we want to do that? Why would we encourage a claim for an injunction or damages? At the point that we launched our application, the only party that proved successful objections was the trust, and the trust had not at that point indicated that it was against what we were doing. The evidence was that Mrs. Devine knew of the covenants, but had not made complaint about our activities. And my lord, if that was the case, then in those circumstances we would have had no reason at all to bring a High Court claim together with an application for modification. One can see other facts and circumstances which would easily make the position more difficult. For example, there might be circumstances where no parties were aware of the benefit of the covenant until they see the advertisements that the tribunal direct ought to be made. And in those circumstances, if it's then suggested that because the objectors learn of the benefit of the covenants from advertisements that have been made, that we then have to issue High Court proceedings, joining the very often hundreds of objectors that sometimes put in objection notices to proceedings in the High Court, that would be a recipe for, well, it's utterly impractical. Let me just really leave the point by saying that. Lord, can I then just address a couple of points? I know I'm short on time, but let me just address a couple of points that my learned friend made. He indicated that we had abandoned a part of our written case. I have to say I wasn't quite sure which part my learned friend thought we'd abandoned, but I just wanted to reiterate that we have not abandoned any part of our written case. And if the impression was created that we had, then that was unfortunate. Yeah. My lord, can I just move on then? My lords, can I just move on then and deal with the point that was made, that my learned friend says to give the respondent, to give the appellant the opportunity to build would be contrary to the public interest. But of course, that's not what the test is. The test is whether or not the restriction in impeding the user is contrary to the public interest. My lords, just moving on, my learned friend relies on the cases of Henley and Welling. I addressed those very briefly on the issue of own wrong. My lords, can I particularly refer you to paragraph 59 of Henley? I won't take you to it, it's at page 213 of the bundle. Also, I do ask my lords to read the Buswell case, which I say does point to the distinction between our case and cases in which that principle applies, namely that this is a case where a public interest, third-party interests are involved. My learned friend then tries to rely on Lawrence and Fenn Tiger and Autocraft in saying that that's the sort of principle that should be applied in circumstances where a modification under the public interest ground is being sought. But of course, my lords, Lawrence and the Autocraft case are injunction cases where a decision is made at the discretion stage as to whether or not an injunction should be granted. And we fully accept that at the discretion stage, the tribunal is entitled to take factors of conduct into account. But the key point on this appeal is, of course, that what is said, what the Court of Appeal have decided, is that the question of conduct comes in at the jurisdiction stage. And we say that that simply is not the case. My lord, it's important to remind, my lords, what the question is here. The question is, did the fact that we didn't negotiate, a party doesn't negotiate, is that fact a bar to modification, whether under jurisdiction or under discretion in relation to the public interest ground? And we say that that is not the case, and it's not borne out by the wording of the statute. My learned friend also relies on the public interest, as he says, is in leaving the covenant in place in the circumstances in which we find ourselves. But that's, in my submission, a question for the discretion of the tribunal at that stage, and the upper tribunal in our case addressed it. He says that the fact that the fact that of the decision would amount to an encouragement to developers to act in this way, but the point is that the whole purpose of the jurisdiction is to deal with the difficulty that the developer potentially faces over the fact that an injunction might be granted, and it's to deal with the fact that injunctive relief may be granted in a way which acts contrary to the public interest under the public interest limb. That is the whole purpose of the jurisdiction. My learned friend says also that the tribunal can't grant negotiating damages. And it is correct that the circumstances in which they consider granting negotiating damages are limited. But can I just take you to one authority? It's the One Step case, and it's in the supplemental bundle, tab 8 at page 275. My lord, this is the judgment of Lord Carnwath in One Step, and he deals with the position relating to restrictive covenants, and in particular, it's under the comment section at 152, where he's dealing with the question of compensation in the tribunal, and makes the distinction about negotiating damages in ordinary cases and in the tribunal by reference to his own earlier decision of Winter at paragraph 151. But at 152, he says, here again, a case can be made for a more generous basis of award, at least in some circumstances. Whereas in the SJC construction case itself, modification is made on public interest grounds, it's easy to see the force of Sir Douglas Frank's analogy with refusal of injunction on similar grounds in the Ruton Park case. My lords, it remains a possible approach where public interest issues arise under the public interest limb. And indeed, of course, my lords, the claim for compensation was advanced by the objectors on the basis of negotiating damages. That was rejected by the tribunal, but there was no appeal against that ruling. So the position my learned friend presents, that there is an inflexible rule that compensation cannot be awarded on the basis of or using a negotiating damages technique, is, in my submission, incorrect, my lord.
Sorry, is that actually correct? My understanding of that paragraph, it's one where Lord Carnwath had actually effectively put in a sort of long footnote, again, after a decision that was essentially concerned with damages at common law. What he was looking at is what the possible effect might be on statutory compensation under Section 84. And here he's saying you can't get, on the face of it, negotiating damages as compensation under Section 84. It would be for Parliament to change it. That's what he says in that paragraph, 152.
Well, my lord, I think what he said in Winter was that negotiating damages was a possible approach, that it could be used as a tool in order to assess compensation. As I read paragraph 152, what he's saying is that that tool may be particularly appropriate where the public interest limb is in play.
Well, I hear what you say.
Right. Well, I think we are moving into injury time, Mr. Hutchings.
But Lord, I fully understand that. Can I just give, if you'll just give me perhaps another minute?
Yes, of course.
My learned friend submits that the discretion should be exercised in the way that Lord Macnaghten set out in the Coles case. But again, we say the answer to that is precisely what Parliament hasn't enacted in Section 84. That is to put, again, a statutory gloss on the clear, open words of the statute. And in any event, of course, the question is a different one under the public interest limb, because a third parties, the public interest is in play. My learned friend repeats the arguments in the written case that the powers of compulsory purchase are in some way analogous. My lord, we do rely particularly on the quotation from Lord Justice Watson from the Prest case, which appears as part of the decision in Sainsbury's at page 531, where he says, the use of statutory authority for the destruction of those rights requires to be most carefully scrutinized. The courts must be vigilant. Well, of course, that really sets out the difference between our situation and the situation of compulsory purchase. Here we have a tribunal making the decision about whether the right should be destroyed. And that's an entirely different situation from the use of statutory authority that is being referred to in Sainsbury's and the other cases that my learned friend refers to. My learned friend submitted that there was that the tribunal was in error in support of the Court of Appeal's decision in placing too much significance on the planning permission. But he suggests that somehow one reads the statute as I understand it, Section 84 1B, because it makes no reference to the express reference to the planning permission, that somehow that shows that it is of less importance than the development plan and the other documents referred to under Section 84 1B. But in my submission, that simply can't be right. It offends common sense to say you put greater weight on a development plan than the actual planning permission. And that is certainly not the way that the tribunals tend to treat planning permissions. There's also an air of unreality about that submission. It's not said what that document in this case would have said and how it would have influenced the tribunal. The point is made in the Collins case that it is not for the tribunal to rehear a planning application, as it were, or a planning refusal. That point is apparent from both the Collins and I think the Osborne case. But my lord, you were taken to Collins, and can I just finally perhaps just take you back to that at 361, because I just do draw attention to the way in which the other material circumstances part of section 1B was interpreted by the tribunal in that case. My lord, it appears in the top of page 361, where the tribunals say that the other documents not referred to in the statute are not admissible, or doubts whether they're admissible. But then towards 6 or 7 lines down, Mr. Newsome argued that any other material circumstances must be construed a justum generis, with the word immediately preceding it as far back only as the comma. In other words, from the word areas, relevant areas, which is quoted. So you read it back with, the submission was, you read it back with only as far as well as the period at which and context in which the restriction was created or imposed, and any other material circumstances. And the tribunal there find, I think that is right, because had Parliament intended to embrace every plan that could be produced, then I think it would have said so. But the reading of other material circumstance, any other material circumstances, is relevant to the submission that my learned friend makes, that you can read any other material circumstances at the threshold stage under 84 1AB to include matters of conduct, and that interpretation would suggest strongly that that is not the case. And my lords, I know I've trespassed too far already. Can I just make one further point?
One final point.
One final point, my lord. I thank you. And it's simply this: can I take you to 300 in the same bundle that we were just looking at? My lord, this is the document you were, I think, referred to briefly by my learned friend, the deed of variation, and it's paragraph 2.3, and this is about the 1.64 million. And you'll see there that 2.3 is altered with a new undertaking, which and the undertaking is that if the Exchange House site has not effectively been transferred by the 30th of September 2017, then the 1.64 million becomes payable. And the point that the tribunal were grappling with in September 2016, which is when they heard the case, is that, of course, it was not going to be for another year that the 1.64 million would kick in anyway, in which case the tribunal's emphasis on the fact that they were dealing with the here and now, and that this housing was available now rather than at some speculative stage in the future, was, in my submission, a good one. My lords, I apologise for the length of my reply.
No, not at all, not at all. Right, well, thank you all very much for your presentations. And of course, we must register our gratitude to those who assisted in the preparation of the printed cases as well. The court will take time to deliver its judgment, and you'll be notified in due course when that is ready. Thank you very much.